Yes, switch. Well, we're going to look at Paley and Waltham Forest.
That's right, and we probably don't need to spend too much time, so I do appreciate the court's familiar with it. But the paragraph really I was hoping to take. Paragraph at page 479, 64, paragraph 64.
Yeah.
So the whole point of the process, including the right to make submissions by the applicant as part of the discharge by the local authority of their duties, and the makes the point that the mindfulness is proactive. The local authority is making further inquiries, having considered their applicant's submissions, they're minded to make the decision they've reached based on those inquiries. The effect of the minded to letters, so that before finalising that decision, the applicant is given further opportunity to inform the local authority of any other areas which should be further investigated. So the reason I rely on that authority is this is a case where there was a minded to letter sent. You can find that in the supplemental bundle at page 22.
Yes.
And in terms of this decision and how this appeal is being argued, I'll take to page 26 of that letter, about halfway down the page, beginning on based on client circumstances.
Sorry, page 26.
Page 26, about halfway down the page.
Yes.
So that makes a point, which I think is something, my lord, that you picked up on earlier, that they had the benefit of mind too, that this is a zone 1. I don't think that's been pursued any further today. It also advises the applicant of the steps taken to confirm about if there were any other suitable properties available at the time the client was offered 10 Whitehorn, and then informed the only accommodation that was available and ready to let was Whitehorn Avenue. We then see the response to that, which appears at page 35. And I would ask the court to just spend a few minutes just glancing through it, but I particularly draw your attention to the fact that actually the key focus of the representations was on affordability, and you'll see that at page 36 of that letter. And in fact, that had been the focus of the case throughout the review. Now, I don't say location isn't mentioned, so I'll take you to that too.
Sorry, what are you looking at 36?
So at page 36,
yeah.
You see the representations which are all concerned with affordability. So the point I'm making there, my lord, is that actually the focus of this review and the representations made in connection with it was on affordability.
Well, they go on at 38 to do with location.
That's right. But then if one looks at what they're saying about location, the point they're making on location is primarily to do with the distance from schooling from the door.
Yes. Yeah, I mean, it's perfectly true to say that they don't say in their representations you haven't looked hard enough.
No.
They do complain about this letter. They don't ask for further details about what happened when the council contacted the placement team, as at page 26, but it is said against you in effect. Well, the council knew they had a duty to house within borough so far as practicable, because the review decision said so, and indeed so did the minded to find letter on page 24. So they knew they had the duty. It's not a question of investigating something that has popped up for the first time.
Right.
The question then is, did they adequately carry out their statutory duty?
Right.
And although you're quite right to say that Cramp and Paley caution against finding legal errors on points that haven't been raised, where there is a statutory duty, as we know from cases like Pieretti, the local authority, or indeed Nesala Mozo itself, the council have to show that they've complied with it, even if the point wasn't raised, which it doesn't seem to have been in the Nowozo case. So that's where the question arises, did you satisfy the duty? I think Mr. Van Heegen is inclined to accept that had the policy been complied with and had the acquisitions officers looked at the websites, relevant websites on the day, that would have been good enough. But, he says, you only looked at your locator, it's called? The Carter database, which wasn't enough.
That's what the appellant asserts. So, first of all, if I can take back to the review decision to begin with, because that's obviously the subject of the appeal.
Yes.
Did this local authority comply with its duty? In other words, was it complying with its duty to secure accommodation within borough so far as reasonably practical to do so?
Yeah.
I say it's quite evident from the review decision itself that this local authority was aware of that duty, because it makes explicit, in contrast to the Zolomoso case, where there is no reference to that duty. So in Zolomoso, the Westminster hadn't even mentioned that it was under this duty.
No, I entirely accept that. Ealing knew perfectly well it had that duty, and it has, if I may say so, it's followed exactly what Lady Hale said it should do. It's got policies in place explaining how it acquires properties, how it allocates properties. The question is, did it follow the policy?
Well, if I may, my lord, I'll break it down into two parts, which is how the appellant argues it. Which, first of all, it was in breach because it didn't look at part 6. So if I deal with that first,
Right.
Because I say, as a matter of law, that's not a breach, because in fact part 6 and part 7 are two distinct statutory schemes. Part 7 is your homelessness part. In other words, this is your crisis section. This is supposed to be the lifeline of last resort. It's all about picking up people who have nowhere else to go and whose situation is desperate, they can't find anything else. Part 6, in my respectful submission, is a distinct scheme because that's dealing with allocation. So it's all about treating people fairly. It's about having a system in place and allocating social properties in accordance with that system. And so it would be unlawful, and I'll deal with the authorities the appellant relies on, but it would be unlawful for this local authority to allocate other than in accordance with its allocation scheme. The reason I say it would be unlawful to do so is because of section 166A of the Housing Act, which is part 6, and you'll find that at tab 1 of the authorities bundle on page 4.
Page?
At page 4, tab 1, page 4. Section 159 deals with allocation of housing, and just briefly you'll see in subsection 1 a local authority shall comply with the provisions of the allocation of housing, and it defines what allocation of housing is. So we're talking about social housing here. So when you allocate housing accommodation, you select a person to be a secure or instructive tenant in housing accommodation held by them, or you nominate a person to be a secure or instructive tenant of housing accommodation held by another person, or nominate a person to be an assured tenant of housing accommodation held by a private registered provider of social housing.
Sorry, where are you reading from?
That's section 1591.
Oh, 159, that was all about 166.
I'm sorry, I was just...
159.
1599 deals with
yes.
what allocation is.
Right. Yep.
And then over the page, section 166A, which is at 4 of the authorities bundle. It provides that every local authority must have a scheme, the allocation scheme. I'd ask you just to glance through that section. You can see it does make a provision about authorities within that section, or reasonable preference to be given to people, one of whom is the homeless within part 7. But it does include other people, including people with medical needs or in central overcrowded conditions.
Yeah.
And you'll also see, and the reason I'm going to take you to this will be apparent when I conclude this submission, is it also makes provisions as well about other people, including those. This is at section, it's at page 5, it's the end of section 3, so it goes over to the end of page, goes on to page 5. Frame to give additional preferences to people, which includes people who have been in the regular forces and suffered serious injury or disability, which is person service. That might not sound very relevant now, but when I talk to you about queue jumping and the effect of allocating outside of scheme on the impact on other people, this is why I say the local authority's approach was lawful in terms of not seeking to allocate within Part 6, which is what the appellant is arguing. So most significant.
But that would depend on what the scheme was, wouldn't it?
The allocation scheme is a separate thing because that's under Part 6. And if I think if I take you to subsection 13, it will all make sense. I'm sorry, subsection 14, which is page 7. A local housing authority shall not allocate housing accommodation except in accordance with the allocation scheme. They are two distinct schemes. Part 7 is concerned with homelessness, Part 6 is concerned with the fair allocation of housing. And I can take to authority on that.
But we don't know what the allocation scheme was, do we?
The allocation policy under Part 6. But that's, in my respectful submission, that's not relevant to this case because this wasn't an allocation of property. This was seeking to secure accommodation for somebody who was homeless. The applicant was entitled to bid for properties under Part 6 in any event. She was already registered to do so.
I see.
But the way Part 6 works, I'm sorry if it took me so long to get there, but the way the Part 6 works is the applicant on Part 6 will bid for properties themselves. It's supposed to be proactive, it's supposed to give them a choice. It's not a passive system, but they have to wait their turn. There's lists of priorities that must be followed, and they will move up the list depending on how long they've been waiting and depending on their circumstances. Some people have more priority on the Part 6 scheme than others, but it is distinct from Part 7, and a local authority can't allocate other than in accordance with the scheme. So she was already on Part 6.
But suppose that a scheme, in accordance with section 166A3, says we give top priority to people who are homeless. That would probably be a lawful scheme, wouldn't it? Allocation scheme.
Well, yes, because a local authority...
So when a homeless person comes along and says, I'm homeless, the local authority wouldn't be prohibited, would it, from looking at Part 6 accommodation?
Yes, in my submission they would, in terms of it is for the applicant under Part 6 to bid, because the whole point is it's a bidding process, they bid, but they can only bid for properties which they're entitled to bid for in terms of where they are on the waiting list and their priority. What a local authority can't do is offer properties outside Part 6.
So it depends on the bidding.
That's right, the applicant bidding. So if I address you on the cases that my learned friend relies on in support of his argument, so you were taken first of all to the case of...
Where do we find out about the bidding?
Sorry, if I can just...
Is that mentioned in somewhere in the evidence?
So if I just, while we're here, if I take you to one document in the bundle, which also explains the difference to the applicant itself. So if I can ask you to look at the supplemental bundle at page 14.
Right, this is...
So this is the letter...
This is the original letter accepting the house.
That's right.
Right.
And if you turn over the page to page 14, additional information,
Yeah.
that explains to the applicant that they can apply to join the council's housing register. And in fact, a homelessness applicant will be placed in band C, so in other words, they get reasonable preference. But it also makes the point in the penultimate paragraph people in Band C on the housing register have very little realistic chance of bidding successfully for social housing in the short or medium term. This is due to the shortage of permanent accommodation and because there are many people in higher bands who have more priority. So that's part 6 is your route into secure accommodation or an assured tenancy. It's a waiting list, it's about being fair to everyone.
So just to me, so I can understand this. Yeah, I don't think we've got the allocation policy, but I think what you're asking us to take from this is that, first of all, the allocation policy allocates housing to people who are on the housing register, not to people who are not on the housing register.
That's right, so it's determined in accordance with that.
You can, as a homeless person, you can apply to be put on the housing register. And if you do that, this letter explains, you will go into Band C.
Yes.
Once you are on the housing register, you can bid for social housing, but as a Band C, you haven't got much chance of getting it in the short or medium term.
Yes.
Since the allocation policy allocates housing to people who are on the housing register, allocating housing to someone who is not on the register would be prohibited by section 166A14.
Yes.
And therefore the council did not have to look at its part 6 accommodation in satisfying its section 208 duty. I got the argument right.
That's right. And of course, the duty to make inquiries is really a Wensbury reasonableness test. Was it Wensbury unreasonable not to look at part 6? And I say, well, no, it wasn't, because it would be unlawful for them to allocate other than in accordance with the scheme.
I thought it was being said before the short adjournment, though the fact that subsequently looked meant that it didn't take it any further and it wasn't really being pursued, the part 6.
Well,
what they were concentrating on was the temporary accommodation acquisitions policy, which presumably is the next stage. So you're not going to get something from your part 6 bidding, but that leaves you as a homeless person and the housing authority with its duty, its housing duty, still unsatisfied. And what I think he was saying is then when you get to that stage, you then look at the temporary accommodation acquisitions policy, and they fail to comply with that.
So that's the point I'll come on to next, but can I just draw the court's attention to 2 points in relation to the appellants authorities? If he's not pursuing part 6, the point about part 6, then I don't need to spend any time on this, but the authorities you were taken to on the appellant's case, Al-Kumdi and also Begum. So Nipa Begum was at tab 3. And
Begum is a decision of 1999,
Yes.
and according to the notes on page 7, this came in with the Localism Act, is that right?
that's right. The only brief comment I was going to make on that is a case where there was a breach of the main duty or the housing duty in any event. The local authority had put them in unsuitable accommodation and acknowledged that they were in breach of their duty. So that doesn't help the appellant on his part 6 argument anyway. I mean, I don't want to spend any time on this if it's not being pursued, but it was just to draw the court's attention to both that case and Al-Kumdi are both concerned when there has been a breach of section 193. So in other words, the local authority isn't providing suitable accommodation and they were being JR'd because they'd failed to perform their duty.
Yeah. But as at the date of the Begum case, was there section 166A or its equivalent in force?
No, I don't think so, but what there was in the Begum case was section 207, which has since been repealed, and section 207 is set out at page 103 of the Begum case.
103.
Yeah. So the point about the Begum case is what the local authority were criticised for doing is they were trying to avoid having an immediate order made against them They were saying we're doing all we possibly can, but the point in Begum was, well, why don't you take your Part 6 stock out of Part 6 and allocate it as Part 7 accommodation, which is a different point to allocation altogether. Does that make sense? Have I...
It's all set out, isn't it? Page 103 starts, it's essential to bear in mind the duties under 6 and 7 are separate.
That's right.
And that's what you've been talking to us about.
I was keen to emphasise that because this is something that, you know, is of particular importance to read.
6 is permanent accommodation involves joining a queue. 7, no such recognition.
Well, if I now address you on private accommodation.
You're not saying Begum is wrong?
I'm not saying Begum's wrong in the context of a local authority having failed to perform its section 1932 duty, but the ratio of Begum was that actually the duty, if you owe duty to provide suitable accommodation, it's an immediate duty. And where the local authority had gone wrong in Begum is they weren't performing that duty, they hadn't performed suitable accommodation, and they hadn't satisfied the court that they had done enough to perform that duty. So in other words, they couldn't say to the court, don't make a mandatory order, we're doing all we can. The court said, well, actually, why don't you look at Part 7 and Part 6 and reallocate that and use it as Part 7 accommodation, which is a different point and not the point raised in the Appellant's Notice. The Appellant's point raised was it should have been looking under Part 6 at Part 6 allocation, and my response is that would be unlawful.
Yeah.
Well, the thing about that was that if they do, they can borrow, if you like, Part 6 housing for Part 7, but only on a temporary basis.
Yes, yes. But in the context of local authority, that's already in breach of duty and trying to avoid a mandatory order.
Yes.
So if I move on to what's said, the criticism that's made about the private sector, I've already made the point that actually, contrary to the appellant's case that they were constantly arguing or constantly asking what's happening with private accommodation, why aren't you looking? That's just not right. The emails you were taken to at page 75 onwards in the supplemental bundle all post-date the review decision. So that's my first point.
Well, yes, they do, but they're asking what did you do?
Right, so if you're against me on that point, first of all, we look at the review decision itself. Well, in fact, my lord, I can actually go further than that. I'm going to go back in time. If I take you back to the actual acceptance of duty letter in the first place, I mean, the appellant's argument that, you know, they were excluding private accommodation from consideration. But if we go way back in time to when duty was accepted, and you'll see that at page
13.
At the supplemental ones at page 13.
Council intends to arrange for a private landlord to make you an offer.
So that's how it wants to perform its duty.
Yes.
We then look at how it goes about doing that. Well, we know it's got two policies in place. The temporary accommodation allocation policy and its acquisitions policy. Now you'll remember in Zola Mesa, one of the criticisms is what is the local authority doing to perform its duty to provide accommodation in the borough as far as reasonably practical, and how does it evidence that? And as Onomasa said, one of the ways you can evidence that is by having a policy. So the policy sets out what this local authority is doing. And if we start with the temporary accommodation policy itself, which is in the supplemental bundle at the back at page 82.
Yeah.
The first point I'd make that is the policy covers interim accommodation, temporary accommodation, and also private rented sector accommodation. So in other words, this policy is covering private rented accommodation. You'll see further down the second paragraph, this policy does not cover placement into permanent social housing or secure assured. It also says it should be read in conjunction with the temporary acquisitions policy, which I'll take you to briefly later. But in terms of if you read through the policy, at the very last page, at the very last sentence of paragraph 82, the council will, whatever reasonably practicable, try and secure suitable accommodation in the borough of Ealing. So in other words, this is a local authority that clearly
I'm
doesn't.
sorry, you've lost me. I've lost.
I'm sorry, I'm going too fast. At page 82, the last paragraph.
The supplementary bundle.
That's right.
Right, got it. Thank you.
The council will, whatever reasonably practicable, try and secure suitable accommodation in the borough of Ealing.
Yes.
Over the page is the assessment process, which we looked at in the context of round one. I don't think I need to sort of highlight anything particularly there. At page 84, it's the third paragraph, which begins as stated wherever possible.
Yep.
It will aim to place applicants in borough, prioritising where it's not possible to do so. Also relevant is at page 85. It's the fourth paragraph beginning where households are placed in zones 2 or 3. Council will endeavour to move them into zone 1 or 2 if availability of suitable accommodation and competing priorities allow. And then advises the applicant of the difficulties it is facing. I know the court will be familiar with it, so I don't tend to spend any time on it, but the difficulties by things such as the welfare benefit cap, no accommodation within borough that might be suitable based on affordability, that's page 85. And pausing there, I do make the point that, of course, location is relevant to suitability, but it's just one aspect to it. There are other aspects, some of which have to take priority depending on the circumstances. Affordability is one, it's a statutorily relevant criteria. There is no point placing applicants in borough in accommodation they can't afford if they then end up being evicted. You don't break the homelessness cycle that way, and it just causes more disruption. It's no kindness. So I do make that point. The local authorities having to balance all of these very difficult competing considerations. And then also relevant to this is the acquisitions policy itself, which is the unagreed bundle. Yep. And you'll find that on page 7. And you'll see there the temporary accommodation acquisition policies applies also to offers of private rented sector accommodation. So in other words, it's private accommodation as well. This borough isn't somehow limiting itself in some way and not looking, it does. It sets out the aims, and you can see actually this local authority is quite focused, I would say, on trying to accommodate within borough. It's identified its aims, what it's going to do. It also makes the point that it will, the second bullet under aims, acquire properties within and close proximity to the borough of Ealing wherever possible. And the last bullet, which I think your lordship may have looked at earlier, to work with private sector landlords. All of this is evidence that actually the local authority, when it places people, it's not limiting itself in some way to what it's looking at, and it's not in its interest to do so. Any local authority placing an applicant wants them to be satisfied with that offer. It makes more sense, because otherwise, if they're not satisfied, you do end up with appeals, which is more expensive, and all of that cost is coming out of the pot that's available to other applicants. So it makes sense for local authority to try and do their very best.
But the policies, if I may say so, are excellent policies, and they do everything that policies should do. The question is, did Ealing actually implement the policy?
I would say yes.
Well,
So
that's the debate between you. I mean, Mr. Van Heegen says, no, you didn't. We asked you what you did. You said you looked at the Carta. You didn't say that you followed the policy by your placement acquisition team looking at relevant websites on a daily basis. You never said you looked at websites. All you said was you looked at your internal database on the Carta.
Well, I would say 2 points in relation to that, my lordship. First of all, that's the applicant asserting that. You have before the court the document from the placement officer who advised there were no four-bedroom properties available. There's no reason for limiting that in any way. That's just pure speculation. They know what their job is. They know what policies they're applying. To suggest they're somehow going to limit their search would just be pointless. The other point I'd make is it then strays into a territory, well, is this a reasons challenge? Has Ealing not said enough in its review decision about what it's doing? The point I'd make in relation to that is Olameso explicitly recognises that actually having a policy is evidence of how you go about allocating properties. I also refer to the case of LadyJustice, which is in the authorities bundle at... Yeah,
I mean, what Alibet says is that if you've got a policy which is lawful and you do what the policy says you should do, then your decision is likely to be lawful. And that we're back to the same question. Policy is fine, Ealing's policy, there's nothing wrong with Ealing's policy. Did it follow it?
Well, my submission would be, well, what more is a local authority supposed to do in these cases if it's applying its policy lawfully? Couldn't find any four-bedroom properties. What more evidence?
No, but I'm sorry, that's not the point. As my lord says, you've got a great policy. You've got them nicely divided up so someone can understand the difference between allocation and acquisition. Excellent. But the point that it is being made is that the local authority, the housing authority, did not follow its own policy, because it didn't, whilst it looked for the Part 6 properties, it did not look for private accommodation before saying, you're not in Zone 1, you're out of borough.
And
there's no evidence that suggests they looked at private properties in the borough.
Just to pick up the point that you said, what else can the local authority do? The answer would be, or an answer would be, when asked, what did you do? Local authority would say, well, we looked at Locata, and we looked in the local paper, and we looked at websites, and this is all we found. So those three things that they could have done. Nobody's saying they had to produce a four-bedroom property in Ealing, but the complaint is you didn't look hard enough.
And my answer to that would be the reviewing officer was entitled to make inquiries of the placement team who allocate properties in accordance with the policy, which also covers private rented sector offers.
Okay.
And the response they got back was there were no four-bedroom properties available. In my respectful submission, it's not the same as saying that response doesn't mean there was only... They were entitled to conclude it meant that what it said, there were no four-bedroom properties available. That would be my point, my lord.
So you ask us to imply within that inevitably the policy had been pursued and fulfilled, and accordingly when they're saying there are no suitable properties, four-bedroom properties available, it means we looked in all the places that the policy says we should look.
Well, the policy governs how placement officers go about making offers, and the policy covers private rented sector offers as well. It's not just about temporary accommodation, it's also about private rented sector offers, so it covers both. So I think I say the evidence is there for you to be satisfied, or more for the reviewing officer to be satisfied that's what occurred, and that there was nothing.
So you say that If in the acceptance of duty letter,
Mm.
no, I'm sorry, where was it in the acceptance of duty letter where it said that we've asked the placement officer? Or was that in the
Acceptance of
review?
duty,
That's
that's
in the review.
That was in the review. So, sorry. So you've got your acceptance of the duty, you've got your policies. You say in your review, we've asked the placement officer. We know the placement officer is governed by the policy, and therefore, because the policy includes private rented, then that means that we should accept that that indicates that that was done correctly and that they complied with their duty.
Yes, because I don't.
And it's unfortunate, but not fatal, that notwithstanding the emails, albeit they were after the review, that they didn't go on to say, and we also considered at the time our private rental properties available under our acquisition policy.
Yes, that is what I say. Because the difference. So Ealing did look at Part 6 in response to an inquiry that came post-review and also ascertained there was nothing available under Part 6. But the reason it's able to do that was because that is a bidding system, so it could access the applicant's details and get the history that way. In terms of what it's doing, in terms of trying to find accommodation for people, it can be quite quickly. They might have to find accommodation within days. If someone suddenly loses accommodation, they do have to move quickly. If we are asking local authorities to file note every single property they make, in my respectful submission, that does introduce a judicialisation into the system, which the courts have said we should be doing, because the local authorities' decisions are going to get longer and longer and longer. If they can't simply apply a policy, have a policy and apply it.
This begs the question,
yes.
Did they apply it? Now, you say that, well, in effect you say the reviewing officer made the inquiry of the placement team. The placement team said there wasn't anything available. The reviewing officer was entitled to infer, assume, not quite sure what the right verb is, that the placement team had complied with the policy, which would have included looking at relevant websites on a daily basis.
Sorry to interrupt, but I don't think that's quite right, because that would be acquisition rather than allocation, would it?
I think that must be right. Placement people are the people who place, but they do it against the backdrop of the acquisitions policy.
Of it being topped up constantly
right.
under the acquisitions
right.
policy.
That's right. That's right. Well, I think my final submission, if you're against me all of that, would be to actually look at the facts of this case. This was someone who I think is now accepted, it can't be said, fell within Zone 1. So in other words, she could be offered accommodation in Zone 2. She was offered accommodation in Hillingdon, and in fact the accommodation she was offered was just on the outskirts of Ealing. So we know that, for instance, she was able to commute to work within 40 minutes. So did the authority apply its policy lawfully? Well, I would say yes, because it made an offer of accommodation to her that was in accordance with the policy. And I rely on Appellant to say it performed its duty correctly.
So let me just work this one out, see if I understood this. Mrs Abdikadir was not entitled under the allocations policy to be within Zone 1. Even if you are entitled to be within Zone 1, the allocations policy is very clear that you don't necessarily get housed within Zone 1. She was entitled to be housed within Zone 2, and she was housed within Zone 2. And the practical possibility of her being housed within Zone 1 without a Zone 1 priority was negligible. So it would not have been practicable to have housed her in Zone 1. That more or less how it goes?
Yes. And then it comes back to the balancing exercise that's already been done, and I won't tell you, I things you already know, but you know, it does have to do a balancing exercise, looking at all the other people on its list. And I do say due record ought to be given to its policy and how it goes about doing that. You know, this was someone who was fortunately located as close to Borough really as it was possible to be. I mean, you can be in Ealing and have far greater distances to get to work. Her children could attend the same school. So I say in the context of the pressures we know local authorities are under, Ealing did, you know, it's evidence it did a good job because it found her somewhere so close.
And in effect, you were saying, going back to your earlier submissions, that by saying that Ealing should have looked in the brand hub with the private landlords within that, is in effect trying to queue jump in relation to Zone 1 and policies.
Well, in terms of how it allocates its policy, how it allocates property, yeah, absolutely. I suppose the other final point I'd make is, I mean, what further inquiries are the local authority expected to be doing here? Are they expecting to look at websites every day? You know, they know, the policy sets out, they know which landlords will work with them. They know which landlords will provide them with affordable housing. As the policy makes clear, the accession policy makes clear, they're constantly on the lookout for new landlords. But it makes sense for a local authority to build up relationships with landlords who it knows it can trust, because they will understand the needs and demands of some of the most vulnerable people who are waiting for social housing. They know which landlords might show a bit of forbearance if there's any problems paying rents. They'll know what landlords might show a bit of forbearance if someone has behavioural issues or problems as a tenant, which might be attributable to someone seeing disability. These are all the factors they're bringing to bear when they're making these offers of accommodation. You know, it had been suggested in the previous appeal before they came to court, well, hang on a minute, we were able to find a property on Zoopla on that date, but that's not reflective of what's actually available to a local authority. Just because a landlord advertises a property, it doesn't mean that the greatest one in the world, they're going to want to let it to a social tenant. Have I answered the concerns and the questions directly?
You have.
Is there anything else? So if I can just 1 moment.
Yes, Mr. Bendy.
Well, can I reply on ground 2 first, because we've just dealt with that and it's fresh in our minds. Can I ask the court to look at page 77 of the supplementary bundle, because I don't think we looked at that email yet. I'm looking at the top email on page 77. It's from the appellants solicitors of the 4th of August. And they say, could you please provide a list of properties that are available under Part 7 and Part 6 on the date the offer of accommodation was made to our client? So they weren't confining their inquiry to Part 6. They wanted to know what was available generally. It was said by my learned friend, we asked the placement team, and these emails, the ones on 76, 75...
Sorry, just hang on. Is there a reply to this?
No. My learned friend says that the respondents inquired of the placement team. These emails on 76 and 75 that we have already looked at were designed to flush that out. And what in fact transpired is that the inquiry was made of a person initially called Nana, page 21, and who we now know from page 80, in fact called Nina, and Nina was the Part 6 officer.
Where do we know that from?
So, to follow it through, on page 76 and 75, we're asked about the email, which appears at page 21. The email on page 21 is allegedly from someone called Nana saying that only 10 Whitehorn Avenue was available.
Yeah.
So on pages 76, 75, the solicitors say, effectively, who's Nana, where does Nana get the information from? And then on page 79, 80, it is revealed that Nana is Nina Yusuf. She's the part 6, she's the allocations team person. And she got that information by showing that there was nothing available on the Carter because she's the part 6 person.
I'm sorry to intervene during submissions. I know it's terribly rude, but I've just been asked to make the point that actually Nana and Nina are 2 different people.
Right.
So, obviously, that's not what we're told at 75, 76. That's the first we've been told that. But the evidential basis for the assertion...
Wait a minute, sorry. Page 80. This is from Miss Smart to Nina. And what she is asking is they want to know what property was available on locata the day they were made an offer of accommodation under Part 7. So that's the question that is asked. What was on locata?
Yeah.
And you get the reply, there wasn't anything.
Exactly.
But I think your point is that asking what was on locata is not the right question.
Exactly.
The question is what was available, whether it was on locata or not.
That's the email at the top of 77. That was the question, and it was never answered.
Yeah.
And at the top of page 76, which is the end of an email that starts at the bottom of 75, it says, regarding properties available under Part 6, you'll be aware that these properties are allocated under the Council's allocation policy by a choice-based letting scheme, which requires an applicant to bid successfully for a property. As such, Part 6 accommodation was not considered by the reviewer when checking what accommodation was available at the date of the offer. I know you've taken us there before.
So finally, just in my response on ground 2, I want to just go back to the authorities and look at El-Kundi first and then section 193. Because what we're not saying is that the appellant should have been allocated accommodation under Part 6. That's not what this case is about. This case is about how they discharged under Part 7. And my lord made some criticism of Begum because it's an old case. So can I ask the court to look at El-Kundi, which came out a few weeks ago, which in my submission says basically the same thing at paragraph 134, which is on page 456.
Sorry, page
456. Can I invite the court just to read paragraph 134, please? In my submission, the respondents in this case fall foul of the requirements set out in paragraph 134 to demonstrate the steps it's taken. And then finally, if I could refer to section 193, which is on page 22. There are basically three ways in which an authority can discharge their duty under Part 7 by offering accommodation. The one that's relevant in this case is subsection 5, but there are two others. So subsection 5 is on page 23. They can use Part 6 accommodation. That's page 24, subsection 7. They're not making an allocation under Part 6. It's not an allocation decision. It's taking some of their Part 6 accommodation and giving it to the applicant under Part 7 and discharge of Part 7. It's the top of page 24, subsection 7. And the third and final way they can do it is by using the private sector. And that's...
Sorry, what's an offer of accommodation under Part 6 other than allocation under a housing allocation policy?
Because this isn't an allocation, this is using Part 6 accommodation to discharge the Part 7 duty. That's the passage we just saw in El Kundi. Right. It may also be an allocation. They may be making an allocation, but there's a separate point that you can take your Part 6 accommodation and use it for the purposes of Part 7.
But as a temporary, as we know.
Yeah, exactly. It's a temporary, but then it's not a Part 6 allocation.
So that's why I'm confused. Because I read that refuses final offer of accommodation under Part 6. So that's when you bid, you get it, and you make it, an offer's made, and so it's a Part 6 allocation. But if they borrow a Part 6 property for temporary accommodation, that's a Part 7 allocation, surely.
Exactly. Part 7, which will come under subsection 5.
Yeah, so it's not an offer. It's not a final offer under Part 6.
But can I just say one thing about it is it's not necessarily the case that the applicant bids under Part 6, because Ealing's scheme, as in common with a lot of schemes, have a system of direct allocation. So they can make direct offers under Part.
Just help me, why is subsection 7 relevant to what we're trying to work out here?
I don't think it is.
Oh, just you took us to it, so
I
I was wondering why.
Yeah, just to show you that there are three different ways in which the duty can be discharged.
All right, okay.
And then the third is 7A, where you, 7AA, where you use the private sector. So the relevance of Part 6 is not solely...
Sorry, beg your pardon, the third is 7A?
7AA,
Double A, beg your pardon.
where you make a private rented sector offer.
Yep, understood, thank you.
And if you don't look at your private sector, you can't make a private rented sector offer. So you can use your Part 6, but not for the purposes of making an allocation, but just as a temporary under subsection 5. That's all I want to say about ground 2. Ground 1, just dealing briefly with the points in turn. Jurisdiction. As I said, this isn't a challenge to the lack of the failure to notify. If it was purely a challenge to the failure to notify, except my own friend's point, it would have to be by way of JR, because there's no right to request.
You say it goes to suitability.
Exactly. On the trigger point, if one goes back to section 208 as to whether there has to be an acceptance, so that's page 67. My learned friend says that the reference to was made available in subsection 4 is a reference to an acceptance. In our submission, no, it isn't. What it is a reference back in time to the time at which the accommodation was available. So in subsection 2, the accommodation is available at a point in time, at the latest when the offer is made. And then the notification in subsection 3D, you have to say when that was historically, i.e. when it was made, when the offer was made, And then at subsection 4, your period of 14 days runs from historically when that offer was made, when it became available. And that explains the use of the phrase was made. It's got nothing to do with the applicant accepting and therefore the availability being made. So in our submission, they're wrong to say that the time in subsection 4 runs from acceptance. It doesn't. It runs from when the accommodation was made available. And then we get to the purpose. And my learned friends say this section relates only to local connection. And they have to get by on that to defeat the appeal. And in my submission, they're wrong about that. This notification procedure doesn't relate only to local connection. And I've taken the court to AM to show that section 208 is also bound up with the transfer of social services functions, AM being about the transfer of children functions, but it could be about transfer of adult functions as well. So through AM, one can see that it goes beyond local connection and extends to other considerations such as social services, children's needs, children's welfare. The significance of that is plain from the Zalamesu. If I could ask the court please to turn up paragraph 27 of the Zalamesu, which is on page 242. And I invite the court to read paragraph 27, and we say that provides the link with suitability because paragraph 27 clearly links suitability to safeguarding, promoting welfare of children in the household.
I'm sorry, I'm not with this. Why does that relate to notification duty? You can see it relates to section 2081. What's that got? Why does it relate to the notification duty?
So if AM supports the proposition that 208 is relevant to children's welfare, then paragraph 27 of Nzelamesu is authority for the proposition that it therefore relates to the suitability of the accommodation. Because that's what the first sentence says.
I think you're chronologically back to front. Local authority decides that particular property is suitable, and in so deciding takes into account the welfare of children. And that would include consideration of section 2081 about housing within borough, so far as reasonably practicable. Having considered all that, they make an offer, knowing that there are children's interests involved. And at that point, because it's out of borough, they notify the receiving authority, so that the receiving authority is ready for the children as and when they move in. And that's how the two link, I would have thought. I mean, there's also, of course, Ms Screech-Powell's point that what happens if you do notify before acceptance and then there's a refusal, the receiving authority may have scrabbled around trying to find an allocated social worker, all for no purpose, and there's no duty to tell them that the offer's been refused so they can down tools.
My submission is that suitability and children's welfare are two sides of the same coin. And if one accepts, following AM, that notification is relevant to children's welfare, then it must also be relevant to suitability. And the moment one accepts that Section 208 is relevant to something other than purely local connection, the respondents can't make good their resistance to the appeal. Because for the respondents to succeed, they have to show that the notification is only referable to local connection.
Yeah.
To do with my Lord's point from earlier about, well, what happens in a situation where you discharge before you're under a duty to provide the notification. We submit that although your decision might appear to be a lawful decision on suitability at that time, you are nevertheless under a duty to notify, even if there's not acceptance. And if something comes up as a result of that notification, then your seemingly lawful decision is not a lawful one. And that's because you've made a decision on suitability in the absence of a notification, in the absence of any information which might come back as a result of that notification. So a local authority shouldn't be able to benefit from coming out with a discharge decision within the 14-day period. I also want to take the court to the conflict in the authorities about the relevant date. If one looks at page 331 of the bundle,
331.
331.
So this is Waltham and Surley.
Yeah, there's a quote from Omar, which is Omar and Westminster, paragraph 34. And in Omar, the relevant date is said to be the date of the decision. So if the court just looks up between D and E, but it's really at E, it's Omar which takes it as the date of decision.
Yes, well, there they distinguish between where there's been an acceptance and where there's been a refusal.
Exactly. And where there's been a refusal, they say one looks at the date of the decision. Contrast that with page 385, which is the case of Broderick and Bromley.
385.
I just invite the court to read paragraph 43, but it's only the last sentence.
43.
Yeah.
Yes. Well, that's the same thing, isn't it?
No, at the end of 43, it's said to be the date of the offer.
Date of the offer as opposed to date of refusal.
Date of decision, yes.
Right. Well, I mean,
So
the facts of this case, there's no difference.
that doesn't really make a difference. But my lord asked me
But I
about
mean,
that.
the point is that if you're looking at an acceptance, you're looking at suitability right up to and including the date of the review decision.
Exactly.
If, on the other hand, you're dealing with a refusal, you are not. Now, there may be differing views about whether you're looking at as at the date of the offer or as at the date of the refusal, but either way, you are not looking at it at the date of the review.
Absolutely. I'm not sure it's the date of refusal. I think what Omar's saying on page 331 is it's the date of the decision by the authority that their decision has been discharged by the refusal.
Correct. You're absolutely right. I mean, yes, so three. Yes.
Yep.
You're absolutely right.
So just two final, very brief points. In relation to my learned friend's arguments that 208 is only to do with local connection. It would be unnecessary if it was to do with local connection, because very frequently section 208 isn't complied with, and local authorities are perfectly able to make local connection decisions. They just simply ask the applicant for their accommodation history. And
I noticed that Judge Luba's book says the duty is more honoured in the breach than the observance.
So that the argument that it's somehow necessary for the operation of local connection provisions doesn't make sense in practice.
It doesn't seem to be necessary for very much, to be perfectly frank.
And the final point is in relation to my learned friend's argument that the accommodation isn't available at the time of the offer because the entitlement to occupy only crystallises on the signing of the tenancy agreement. My submission, that's a rather artificial way to look at it. Obviously, in my submission, the applicant does have an entitlement to occupy at the time of the offer. That's why the offer is being made. It crystallises in the grant of legal rights by the signing of the tenancy agreement.
Well, the authority has to secure that accommodation is available.
Yes. Those are my submissions in response.
No, thank you.
Thank you.
Thank you, Mr. Van Heegen.
Thank you very much.
Well, lords and ladies, I appreciate I don't have a right reply. I'm sure I'm not seeking to exercise it, but just in response to something that said...
That sounds like a right.
It's just during the course of the reply, the appellant seemed close to be arguing that where the authority went wrong was not seeking to make an offer, not seeking to reallocate from Part 6 into Part 7. I would just make the point that that's not how the grounds of appeal were formulated and permission wasn't granted on that basis, and I've just drawn that to your attention.
All right. Well, thank you very much. We've had some interesting arguments today, and there's something to think about in each of them. So we will reserve our judgment. You will get draft judgments in the usual way, which will be your opportunity to correct our spelling and grammar, not our reasoning or to raise new points. You will know that the draft judgment now comes with a beefed up embargo, which means what it says. On receipt of the draft judgments, we hope you will be able to agree an order disposing of the appeal, but if you can't agree an order, please make short written submissions and we will make the form of order that we consider to be appropriate. Thank you all very much.
All right.